Добрый день, мои друзья. Меня зовут Daniel Gibbons. Я начну на русском. Я адвокат в штате Юта. Я также бывший судья. Я преподавал в институте Левита в течение 11 лет. Я любил бывать во многих городах Украины и Молдовы. В Киеве, в Харькове, Львове, Чернівці, Кишинев и так далее. Я тоже 3 года жил в России. Мы с женой жили в Новосибирске и путешествовали во всей Российской Федерации. У нас с женой 5 детей и 9 внуков. Поздравляю вас с вашим решением изучать право. Вы внесете большой вклад в свое общество. And now, since my vocabulary in legal matters in Russian is very, very limited, I will switch to English. The main topic for this week's lecture is plea bargaining. But before we talk about plea bargaining, I want to talk about the broad picture of the jury trial. When I served as a judge for a period of 10 years, I had a very busy court. My court was what is called a justice court, located here in Salt Lake County, in Salt Lake City in Utah in the United States. A justice court does not handle murder cases or felony cases, but it handles small criminal cases and also traffic cases, but mostly drug and alcohol cases that arise in the jurisdiction. One of the factors of the Justice Court, or one of the features of the Justice Court, is that we have a very, very high caseload. For example, during the years that I served, we had approximately 10,000 cases filed in our court every year. And those were across the spectrum. Some of them were traffic cases, many of them were minor criminal matters, theft, assault. We handled domestic violence cases. We had many, many drug and alcohol cases, including drunk driving, drug possession, and other drug and alcohol-related crimes. During the time that I served, again, we had 10,000 cases a year that were filed in the court. We held one jury setting every month. We blocked out 2 days a month to handle jury trials. On those jury days, we would set approximately 5 to 10 cases for jury setting. Now, we were only able to try one case, but we would set 5 to 10 cases. At the final pretrial before the jury day, this is usually the day before the jury trial, we would have all of the attorneys and all of the defendants for those 10 cases show up in the courtroom. We would then discuss the case with them. They'd have an opportunity to talk with the prosecutor to try to work out some sort of resolution to resolve the case. And if that was not successful, then we would take the oldest case, the first filed case, and that case would be set for jury trial the next day. As a practical matter, almost all of the cases that came on a pretrial were settled by a plea bargain. And the same thing is true with all of the other 10,000 cases that were filed in our court. Theoretically, any one of those 10,000 cases could have received a jury trial. In fact, all of these defendants had a right to a jury trial for the most part. But as a practical matter, we only tried approximately 10 jury trials a year. Jury trials are very time-consuming. They're very expensive, and they take a lot of preparation. On the jury trial, it would be usually a 1 or 2 day trial. We would we would summon approximately 50 citizens into the courtroom. We would then go through what we call voir dire, which is the process of selecting the jury. That might take 2 or 3 hours. The attorneys would ask questions, the judge would ask questions. We'd go through a number of formalities. We would then finally impanel our jury, and then we would finally begin the case, usually about 10 o'clock in the morning. We would break for lunch. The prosecutor would put on evidence, then the prosecutor would rest. The defense attorney would then put on evidence, and then usually by late in the afternoon, sometimes 3 or 4 in the afternoon, or occasionally on the second or third day of the trial, if it was a complex case, we would begin the process of the jury would begin deliberating on the case. So you can see that it would be impossible for us to do a jury trial on all of the 10,000 cases that were filed in the court. But I want to emphasize how that jury trial had an effect on every single case that was filed in our court. Let me explain how that works. Theoretically, every defendant has a right to a jury trial. So the prosecutor knew that he or she, the prosecutor's office, would be unable to trial all those cases. The prosecutor would have to take a look at the evidence. The prosecutor would have to decide how much resource to put into this case. And as the time went on and the case remained unresolved, the prosecutor would have a harder and harder decision on how to approach this case. Often sometimes the witnesses would be unavailable, and sometimes the prosecutor was unable to proceed. And so the prosecutor had an incentive to settle the case. The prosecutor had an incentive either to reduce the charges or to drop the charges completely, or to continue the case to see if it would be appropriate for jury trial. From the defendant's standpoint, the defendant also had this jury trial in mind. This jury trial loomed as a possibility for this defendant from day one. The defendant knew that if he or she did not plead guilty or did not resolve the case, or the case was not dismissed, that he or she would face the prospect of having to face a jury of his or her peers to decide the case. In most cases, the jury or the defendant would want to hire an attorney, and that would entail expense, or request the appointment of an attorney from the court. And as time went on, the defendant would face more and more pressure, more and more incentive to resolve the case. So this shadow of the jury trial casts its image over every single case in the court. In a lot of ways, it's like a sheepdog in a field moving a herd of thousands of sheep. A very small number of sheepdogs, 1 or 2 or 3 or 4 sheepdogs with a shepherd, can efficiently move thousands of sheep from field to field or from grazing land back to the fold. And that is exactly the way the jury trial works. If you were to see a video image of sheepdogs at work, they don't touch the sheep, they don't hurt the sheep, they don't bite the sheep, but the specter, the presence of that dog influences all of the sheep. The sheep will move out of the way to avoid being in contact with the dog. And that's the same thing as the jury trial. The jury trial, the concept of the jury trial is like a sheepdog. It is present in the field. Everyone is aware, every sheep is aware where the dog is. And the sheep, in most cases, want to avoid coming in contact with that dog. And so as we go through this discussion of plea bargains, I want you to keep that image in mind, because plea bargains are one of the main avenues for resolving a case without going to jury trial. The other ways are for the defendant to plead guilty, or to accept a plea bargain from the prosecutor, or have the prosecutor simply decide this case is not worth pursuing, I don't have enough witnesses or enough evidence. And all of those things failing, then we go for the jury trial. But again, in my court at least, in my jurisdiction, It was approximately 1 in 1,000 cases that ever got to jury trial, and yet that jury trial was one of the most efficient and influential features of the jury trial system.
I'd now like to talk about the feature of prosecutorial discretion or independence in the making of plea bargains. Before I do that, though, I'd like to think of the jury trial, the American jury trial, in terms of a drama or a play. And that drama or play has at least 5, maybe 6 principal actors. Each of those actors are, to a large extent, independent in their own sphere. The first actor, or the first participant in this jury trial, is the police. The police obviously are independent. The police have a crime reported to them. They come up upon a crime. They investigate the crime, and then they decide whether to either arrest or to bring charges. However, that's really the end, other than testifying at the trial. That's really the end of the work of the police. In the American system, the police, their role essentially ends once charges are filed. Those charges are then turned over to the prosecutor, which is the second actor in this drama of the courtroom. The prosecutors also have wide discretion, great independence in deciding whether to bring charges or not. The prosecutors don't control the police investigation. That means that the police need to build their case on their own, and once that case is built, they turn it over to the prosecutor. The police independence and the prosecutor independence are protected under the Constitution, and it's a very important wall that is built between the prosecutor and the police. In order to ensure that only quality cases are prosecuted, American prosecutors are given a great deal of independence, wide discretion to decide which cases to pursue and which cases are dropped. The police don't have a say what cases are dropped or which cases are pursued. The judge can't decide that. The prosecutor has that independence. Once charges are filed, then we have another party brought into the drama of the jury trial, and that is the defendant, and then often the defendant's attorney. We also have the jury, of course, the jury itself, of course, which is independent in its sphere, and then witnesses. So those are all the participants in this trial. And I loved being a judge. I loved coming to court every day. The courtroom was set up specifically to let this drama play out, and to watch this endless parade of humanity coming before me as a judge was just endlessly fascinating. It was like reading Chaucer's Canterbury Tales with this endless flow of interesting people and situations and stories that were played out before me in that courtroom day by day. It was just endlessly fascinating. So again, getting back to prosecutor independence, prosecutors may choose to pursue the original charge that was filed by the police. Let's say, for example, that it was a charge of robbery, or they could pursue a lesser charge, a lesser included charge. If they didn't think they had the case to pursue a robbery charge, they might pursue a theft charge, or an assault charge, or a disorderly conduct charge, some lesser charge, in exchange for a defendant's agreement to plead guilty. And so we have these two independent actors in the jury trial, the prosecutor and the defendant, often represented by his or her attorney, making a decision before the case even gets out of the gates whether to accept a lesser charge. In my court, there would always be a pretrial for every case filed. Each defendant had the opportunity to talk to the prosecutor and decide the prosecutor to decide whether to proceed with the case and the defendant deciding whether to plead guilty. In almost every case in my court, the prosecutor would offer some lesser charge in exchange for a guilty plea. The defendant had a limited time to accept that. Juries, which are sort of the ultimate actors in this drama, in fact, really they're the audience in a sense, together with the judge. Juries must come to a unanimous verdict based upon their independent, private deliberations. They will watch the evidence in the court, almost like playgoers sitting in a theater, and come to their own independent decision. No one can tell them what that decision should be. The police can't tell them. The prosecutor cannot force them one way or the other. The judge even cannot tell the jury how they should decide the case. If the jury cannot come to a unanimous decision or a unanimous verdict in a reasonable period of time, and this happened from time to time in my court, the judge may call for the end of the trial and allow the prosecutor to decide whether or not to retry the case. But if the case goes to verdict, if the case is completed, the prosecutor may not bring the charges again. That's it. It's the only bite at the apple that the prosecutor has. And prosecutors can be held responsible for their charging decisions, even though the judge can't tell them what to do. They ultimately are responsible. They're either responsible through elections in the United States. Most chief prosecutors in cities or the federal system, they are either elected or they are appointed by elected officials. In states where prosecutors are appointed, that review is made by a member of the executive branch. And so the prosecutors are ultimately held responsible, but they are not responsible to the judge. So one of the basic features of the American jury system is that prosecutors have discretion whether or not to bring charges and what those charges can be. They also have the discretion to strike a plea bargain with a defendant to resolve the case before it even goes to trial. I'd now like to spend a few minutes and discuss how plea bargains are struck, and maybe even ask the philosophical question: why do parties even agree to plea bargains? Plea bargains are struck or made between defendants and prosecutors, and then they're reviewed in the court. In other words, the prosecutor sits down with the defendant, they discuss the case. The prosecutor, in most cases, will offer some sort of a lesser charge. The defendant, usually after consulting with an attorney, may decide to take that charge. Because a prosecutor can choose which charges to press in court, and because the defendants can either choose to plead guilty or not guilty, the parties can choose to reach this plea bargain, outside of court. As a judge, I was never able to review which charges were brought against a defendant. I couldn't force a prosecutor to bring a charge, nor could I influence whether or not a defendant pled guilty. The prosecutor was independent, the defendant was independent. However, in the court, I did review the plea bargain with the defendant to make sure that the defendant understood what they were doing and the consequences of their actions in striking the plea bargain. What I would do is we would hold a hearing, and it would usually be a change of plea hearing, where the prosecutor would be present, the defendant would be present with his or her attorney. We would call the case. The prosecutor would go to the podium and explain to me what the charges were, and that the defendant was anticipated to change his or her plea. The charges would be in writing. The defendant that would then come to the podium with his or her attorney, and I would then go over the charge with the defendant. I would make sure they understood what the potential sentence for that charge would be or penalty. It might involve jail time. It might involve fines. The defendant would have no guarantee what the sentence would be, but I would need to make sure that the defendant understood what the charges were and the consequences of pleading guilty. After I was confident that the defendant understood the charges, then I would receive the plea. The defendant would then plead guilty or no contest to the plea, and then we would set the case for sentencing, or in minor cases, in many situations, we would simply do sentencing on the spot. We would do sentencing during that hearing if the defendant waived time for sentencing. In the United States, appellate courts, the state supreme courts, federal courts, they have held routinely that a plea bargain agreement cannot be broken by the prosecution. In other words, once that plea is entered, once the prosecutor has offered the plea and the defendant has accepted the plea, the prosecutor is stuck with the charge. The prosecutor can't wake up the next morning and go, or say to himself or herself, I think I made a mistake. I think I would like to proceed with this case. Or if the prosecutor discovers other evidence, stronger evidence, the prosecutor is stuck. The prosecutor cannot break the deal. However, appellate courts have held that defendants can drop the plea agreement. The defendant can decide, I don't want that deal, and can later go back on it. So that's generally how plea bargains are struck. Let's consider why parties might agree to a plea agreement. From the defendant's side, a plea agreement is attractive because the defendant has some certainty as to what the potential outcome would be. If a defendant is charged with a very serious crime, such as homicide or assault with a deadly weapon, the prosecutor or the defendant has no idea what the potential ramifications of a plea or a verdict on that would be. However, with the lesser included offense, the defendant knows this is the worst case. This is what I can expect, but I know that I'm not going to be. Let's say that the plea agreement was to reduce a homicide charge to manslaughter. The defendant would know, I am not going to face the death penalty. I'm not going to face potential life in prison. I might have 5 to 10 years in prison. I might have a fine. So there is, from the defendant's standpoint, there is some certainty as to what the potential worst case is. Also, from the prosecutor's standpoint, there is an incentive to offer a guilty plea on a lesser charge, and that is because there is always uncertainty as to whether you'll prevail with the jury. You might have witnesses not show up. The witnesses might not be as strong or as persuasive as you imagined. You might have new defense attorney that might come into play that would be persuasive with the jury. So there's always an incentive for either side to reach some kind of a resolution. And then get back to my earlier comment about the 10,000 cases that were filed in my court, with only 10 of those cases going to jury trial each year. It is impossible for a prosecutor to try every single case. There is simply not enough time in the day, enough money to pay for all of those prosecutions, and so there is a practical reason for resolving as many resolvable cases as possible, so that you can save your ammunition, save your greatest efforts for those cases that are winnable and significant. So again, that's a summary of how plea bargains are struck and why parties might agree to them. I hope by now you've had a chance to review the change in Washington article, quote, "where the deer and the antelope play." I'd like to discuss some principles arising from that article for a few minutes. I'd like to discuss the advantages and the disadvantages, or maybe to reiterate some of the advantages and disadvantages of plea bargainings. In English, we call this pros and cons. A pro is an advantage, a con is a disadvantage. First, let's talk about the pros of plea bargains. Number one, plea bargaining allows prosecutors to more efficiently manage their workloads. That means to spend the most time on the most important cases, and also to show mercy in appropriate cases. Prosecutors are not heartless men and women. They are very public-spirited, wise, and thoughtful people who are not merciless, but they often show mercy. I saw this time and time again in my courtroom where a defendant would come in and the prosecutor would have a heart and decide to offer a plea agreement because it was in the interest of justice. And that was often the phrase that was presented to the court. Your Honor, in the interest of justice, we would like to dismiss these charges, or in the interest of justice, we would like to reduce these charges. So again, that's the first pro or advantage of plea bargaining. It lets them manage their very, very heavy caseload. Second advantage or pro of plea bargains is that defendants can avoid a painful or a costly trial. They can take responsibility for their actions, and they can ensure that the consequences of their crime is manageable. They can soften the seriousness of the sanctions or the sentence against them. The third advantage of plea bargains, they limit the power of judges, meaning the judge cannot control the prosecution or vice versa, and it limits the potential for corruption. Let me comment on that for just a minute. During the time that my wife and I lived in Russia, we worked with an individual, an American citizen, who was charged with a crime in the Russian courts. And I was involved to the extent of hiring a defense attorney and watching how this whole thing played out. And having been a former judge at that point, it was very interesting to watch how the justice system operated in Russia. First of all, the entire trial from the time of arrest until conviction and sentence was less than 24 hours. I was also shocked to see that the prosecutor was really the one in charge of the entire operation, directing what the police did, in fact, even to the extent of directing what the judge did. And I'm not saying there was corruption in this case, and it was a fairly minor matter that resulted in the deportation of a friend of mine from Russia because of a trespassing charge. But I just had the feeling that given the swiftness of this case, that there was a great potential for corruption, and that is true also in the American system. If the judge was the one who could direct the prosecutor as to what charges he or she could not or must file, there is a great potential for corruption, and the walls of independence that exist between judges, prosecutors, defense attorneys, and the jury is a great protection for the system. So let's talk about some disadvantages of the plea bargain. First of all, and this comes from the article that you've just read, some might argue that because prosecutors hold too much discretion on what to charge, that they have too much influence, too much leverage over defendants in plea bargain situations. And that might lead to innocent people deciding to plead guilty when they're not guilty, simply to avoid worse consequences. Or it might lead to increasing the total amount of prosecution pursued, even with weak evidence. And so that's actually a very good point. And the safeguards against that are as follows. First of all, the prosecutor does have to stand responsible either to the public at large in a general election, which is typically held every 4 years. And in addition, the prosecutor has to explain the plea bargain to the judge, and the judge has to scrutinize that plea agreement. And if there were any corruption or any under the table dealing, in my opinion, that would come out when that plea bargain is presented. But that is a big disadvantage of the plea agreement. The danger that an innocent person, just to avoid further trouble, might simply decide to plead guilty to avoid further prosecution. A further disadvantage of plea bargains is that without a full trial, the evidence cannot really be evaluated, and it can't be known whether justice has been done. As a judge, it was very interesting to preside at trials, particularly jury trials, and see surprise come on the faces of prosecutors and defense attorneys when their witnesses, the witnesses that they had decided to call and who they thought were so good, really didn't do well at trial, in fact, might have hurt their cases. It's only after a witness appears in court and when the jury can see the demeanor of the witnesses that we can really, really tell how good a witness is. And so a plea bargain removes the possibility of that witness ever, or that evidence or that witness ever being evaluated by the jury. And so we really can't know fully whether justice is done until the completion of a trial. So that's another disadvantage of plea bargains. Third, accepting a plea bargain may allow some defendants to receive too lenient punishment for their actions, and it may result in a disparate or an inappropriately different sentencing for defendants from different races, cultures, neighborhoods, or socioeconomic backgrounds. Wealthy defendants, there is the potential, might get more lenient plea bargain offers than poor defendants who can't hire an attorney, or who don't understand the charges, and that is a serious issue that has to be scrutinized by the judge and by the appointing authority or by the populace. Final disadvantage of plea bargains: because of mandatory minimum sentences, plea bargains sometimes result in more convictions, which can result in higher prison populations. I have a big concern about this one, that if plea bargains are not even-handed, if they're not properly administered by prosecutors, that it can result in a huge prison or jail population. And again, this gets back to my third point, that a plea bargain might result in too lenient a treatment of people from certain socioeconomic backgrounds, or too harsh for others, that it results in a culturally unacceptable prison population, largely coming from one race or economic background. So let me conclude this discussion about the pros and cons by discussing my experience with prison population. I had twice a week, I had van loads of prisoners come into my courtroom to see me, mostly on warrants, some on on broken parole or probation violations, some who had been arrested for new crimes. And when I first became a judge, this was a whole new experience for me. I can still remember the sound of the chains of the prisoners as they came in through the Sally Port past our holding cells and were brought by the officers into the courtroom, shackled at their feet and at their hands, and wearing the different colored jumpsuits for the different classes of citizen or of prisoners, you know, whether maximum security or minimum security. And when I first encountered this jail population, it was hard for me because I had never really had a lot of contact with prisoners. But over time, in fact, very quickly after I became a judge, this became my favorite part of my service as a judge, because I learned that each of these people had a story. There was a reason, and there was some sort of internal logic in the mind of each of these prisoners to get where they got. Some of them had been wrongfully charged. Some of them had been had good reasons in their mind for what they did. And often, most of the crimes in my city were substance related, drug or alcohol related. It was either people who were on drugs or intoxicated who committed crimes, or they were committing crimes to get money to pay for their drug habits. And so as I worked with this prison population, I became very, very concerned. First of all, that we not hold them when it was inappropriate to hold them, and I let lots of prisoners go on that first appearance just because it didn't seem appropriate to hold them in jail. But second, I was very careful in scrutinizing the work of the prosecutors to make sure that this population had as much access to appropriate plea bargains as a wealthy defendant who might come in with a attorney with $1,000 tailored suit. So we always had defense attorneys standing by in the courtroom when we had our jail transports, and I would readily, on the spot, appoint attorneys to represent these defendants for the very purpose that they could work out a plea bargain on the spot and further the possibility that they'd be released. So that's a longer discussion than I had hoped for on the pros and cons of plea agreements.
Thank you for listening to me ramble on about plea bargains. I want to emphasize a couple of points. First of all, in summary, the independence that prosecutors possess is one of the touchstones of freedom. It is imperative that prosecutors have a free hand, that they are not influenced by the police, they are not influenced by the judge in deciding which cases to pursue and which cases not to pursue. Prosecutors are or ought to be human beings, men and women with a heart. They need to have a sense of justice, but they need to have a heart and give mercy where mercy is in the interest of justice. Prosecutors need to have access to the evidence and then make their own independent decision. And they need to be as independent as the police, as judges, and as the jury. Prosecutors and defendants have to come to plea agreements independent of the court. But the court has a responsibility to review those agreements, those plea agreements, and to ensure that the defendant understands the consequences of entering into that plea agreement. So with that, I wish you well. I'm sorry that I can't be there in person with you in that beautiful land, which I love so much. Я желаю вам счастья и здоровья и успех. Thanks so much. Take care.